Okay, and Mr. Chairman, I'd like to comment that the committee, ECU, met last week. The amendment that was, adopted there has been put in as substitute. We left it outside to read, which I didn't have to do when I first got on this committee.
I pointed to the committee.
This is the bill to allow committee, and I guess anyone else that wants to take advantage of it. The legislation will provide for them to put their utilities underground, which would be a big help to not just, I thought it was more for the urban car. It's not. It's going to be done statewide because they've got some big problem areas, rural areas of the state. Even after this bill passes, their plan has to be approved by the State Corporation Commission. They're limited to $175 million a year of charges, which is, I guess, 5% of their base, 5%. And it'll take place over 10 years. And initially, in the first year or so, the cost will be across the whole state because it's going to affect the whole state. Will be about 70 cents a month per household, and at the end of the 10 years, probably closer to $4. The advantage for everybody in the state, which is the reason for spreading the cost throughout the entire service territory, is it's going to cut by a large amount of the time that it takes to get people back online after a storm such as we had in June of 2012. Some of the areas that may have taken them 3 weeks to get to, they might get to now in half the time as a result of it. So everybody's going to benefit. You all have seen, some of you are on that committee, if you take a look back at the end of the substitute on page 25, they made a change there in D, and the whole thing was an initial response to a rule a few months ago by the SEC. And what they're saying is that the commission may determine what is reasonable and prudent. Before saying that absolutely nothing in there, that section would preclude them from viewing the reasonableness of any prudence of any cost. After the amendment was added in the committee the other day, chaired by Senator Norman, everybody seemed, at least the people who opposed what we're doing, were happy to it. Maybe not totally happy, but happy to it. And the SEC said that this will go a long ways to mediating. You go a long ways, or a short ways to mediating.
But I said we'll have to wait and see the next case how the commission.
Okay. All right. I don't want to misquote. But anyway, that's essentially the thrust of the bill. They're still going to have to get the final plan approved by the SEC.
Mr. Chairman?
Senator Moore?
I'm sure there's some parts of the bill I don't fully understand, but what I've read here I really like, and I think it's a great step forward, certainly help our part of the state, and I hope we can move forward with this.
Any of those who are speaking on behalf of the legislation, Mr. Thomas?
Mr. Chairman, members of the committee, I'm Bill Thomas, representing Dominion. I thought I would just take a moment, Mr. Chairman, and describe to the committee the reason for the amendment on page 25, which was the principal issue of discussion before the CEUR, and it might be helpful if the full committee at least had a little bit of that. If you look at page 25 of the substitute in line 664, subsection D, this section that we're dealing with, 585.1, is the section that in 2007 embodied virtually all of the re-regulation substance that was done in 2007. And we, Dominion, were concerned about the wording in D because of a very recent decision by the State Corporation Commission in our most recent biennial case. In an order dated November 26, 2013, the Commission used the language that's stricken, "Nothing in this section shall preclude," to give itself the authority to override, these are my characterizations, frankly, have the order here, but they use those words to give themselves the power to override substantive provisions of 585.1. Now, it was one specific issue in that case that they were dealing with, but my client, Dominion, was very concerned about the precedence of that and how it might be applied much more broadly and globally to substantive provisions of section 585.1. And we were very concerned that that language be stricken. We had suggested alternative language similar to what you see in line 660 that would have said, "except as otherwise provided in this section." And there were expressions of concern at the CUR that that would take away from the Commission its general power to look at reasonableness of costs and prudence of costs. And we were not trying to do that. That was not our objective. Our objective was, as I said just a moment ago, to not have the Commission believe that this "nothing in this section shall preclude" gave them carte blanche to just ignore substantive provisions in section 585.1. What you have here is a compromise that came out of the CUR, and I don't want to characterize who agreed to it and who didn't, but it was an attempt to solve the concern that Dominion had with this power to the Commission, namely the power to make substantive changes in 585.1 versus their ability to continue to have, as we believe they should, and never intended that they not, the ability to look at reasonableness of cost and prudence. I would just stop there, Mr. Chairman, and say, delighted to respond to questions. I would add one thing. I do think there was a motion from the CUR, as I recall, to recommend reporting to this committee, and as I recall, it was a unanimous vote of the CUR. Thank you.
That is correct. Are there others to speak on behalf of the legislation? Are there any questions on the part of the committee? Mr. Thomas, I know that's school in favor. Are there those who would speak in opposition?
Okay, ladies and gentlemen, the gentleman of the committee, Steve Hanger on behalf of Newport News Shipbuilding, one of the state's largest industrial employers. I'm the president of the CEUR meeting. When you first say that we have no comment, no objection to the undergrounding bill, I think the way they're handling that, if you're going to do this in the Commonwealth, it's an expensive proposition, but they're handling it properly. And as long as the commission has the power to look over the cost and make sure they're reasonably prudent, I think it's going to go well. However, we were presented Thursday, without having seen it, this second version of the amendment to Part D. I would not call it a compromise, because the compromise involved discussions with the parties, and we were not involved in those discussions. Presented with it, was not able to respond because it's a complicated legal issue. I wanted to give it a fight. I've got somebody here to give you a legal opinion on this. I will sit down. We are still opposed to having further language, and I'm glad they put it in the substitute, because now all you got to do is put it back the way it was in the substitute, and worry about the language of the formula. So I would ask, I'd like to see that language go back to the way it was in the 2007 statute. I was involved in the 2007 discussions on behalf of consumers. That paragraph is indeed a very strong paragraph. It's indeed intended to give the commission a pretty good ace, which it does. They played it a couple of times. But it is there for a reason, because otherwise the statute is very favorable to the utility. The statute involves a number of areas where it has dictated to the commission that thou shalt do X, Y, Z, and the commission has done that. But when it gets to a question of a cost, and in this case, the cost was the cost of their equity, the amount of equity they were putting into their capital base, it was a huge amount of money. And this will be viewed as basically telling the commission they were wrong to bring it up. I honestly believe that this is a setback for every consumer in this territory. And I would add that this will affect everybody in that territory as well. So we remain opposed to the language indeed, and I would ask you to pay attention to my friend Mr. Petrini. Where did Mr. Petrini? Okay. To get a little more of the detail. He's the lawyer, I'm just a lawyer.
Thank you, Senator.
Thank you, Mr. Chairman. Edward L. Petrini, on behalf of the Virginia Committee for Fair Utility Rights and the Old Dominion Committee for Fair Utility Rights. Both groups consist of large industrial customers of Virginia Electric and Power Company and Appalachian Power Company, respectively. We remain concerned about a change to subsection D. The fact is that the language in subsection D was fundamental to the enactment of this law back in 2007. It was held up as a critical protection for customers. It was held up by Dominion. We have, in fact, quotes from Dominion's website at the time as to how important this was for the protection of consumers, and it was an important reason for enactment of the law at that time. Yes, Dominion is concerned about the Commission's decision in the November 2013 case, in which the Commission found that Virginia Power's common equity percentage in its capital structure was unreasonable and imprudent. Virginia Power had increased the common equity component of its capital structure from a little less than 48% to more than 55% since from 2008 to the end of 2012. And that results in a significant great burden on customers. We're talking about a huge amount of money. And so this provision was intended to act not as carte blanche, but as a kind of a safety net, that when things got out of hand, the Commission could step in and do something. This is the first time it's been applied to the capital structure issue, but this was the Commission's residual authority, if you will, to step in when things got to be unreasonable. So why are we concerned about this, what was called compromise language? We didn't actually speak to it during the CEU meeting, but it was offered in the spirit of compromise, I think, by the union. Why are we concerned? Well, I guess in our view, we're concerned that when a reviewing court, Supreme Court, which is the court that hears appeals from the State Corporation Commission, when that reviewing court looks at this language as Dominion now recommended, it must ask, it's likely, and we're afraid we're going to face this from Dominion, we're going to face this argument. The court's going to say, why was that language, nothing in this section precludes, why was that deleted? And Dominion's going to argue, well, the reason it was deleted, Your Honors, is because the State Corporation Commission issued this order right before the language was deleted that found the capital structure to be unreasonable and imprudent. And there were numerous financial experts who testified in that case. The Attorney General's expert, our expert, the staff's expert,
numerous experts said, this capital structure is too high. Customers should not have to pay rates that have such a high common equity ratio, because when you have, for every dollar of revenue requirement, as it's cost, as it's called for debt, it costs customers $3 for common equity. So when you increase that common equity ratio, it's a lot of money. So these experts repeatedly and emphatically claimed, and the commission agreed with them, that this was unreasonable and imprudent. Now Dominion has come to the General Assembly and used a kind of blunderbuss to say, well, we want to repeal it. That was a fundamental consumer protection, and